leasing a property to put the actual physical dealership on, it's really important to review the terms of the lease. For example, whether there are certain renewal options for the dealer, right? Most dealers aren't going to enter into a lease for just 1 year or 2 years. They would want the ability to continue to renew the lease, because if the lot is successful, the dealer would want to stay on that, in that premises and that location indefinitely, right? Or for some very long length of time, to not only build the business and grow the business, but also to maintain the business. Now, one thing I have seen in a very interesting case that I had fairly recently has to do with the terms of the lease, and specifically the zoning of the property. Let me give you a little story. I represented a client who was a dealership who entered into a lease agreement to lease a space in Cobb County that the dealer believed could hold a car dealership and was zoned and licensed appropriately to run a dealership. After all, dealerships had been in that space for the last 10, 20, 30 plus years. As far as anybody can remember, there had been a dealership on that space. My client enters into this lease agreement to lease this space in Cobb County. When they go to get their license, oh, by the way, important fact, as part of the lease agreement, the lease said specifically, the premises will be used for a car dealership, right? All good. So the client signs the lease agreement. They're getting their ducks in a row to get the dealership started. They go to the Cobb County business offices to get the permit to operate the business. And the zoning department denies it and rejects it and says that this property is not zoned for a dealership. Well, the client's up in arms. What do you mean? For decades, this has been a dealership. And Cobb County officials said yes, but once the last dealership quit, then it restarted the clock and the zoning rules had changed, and now it had to get a different approval that it didn't have. So my client was not able to actually open the lot. That's a huge issue, not only because they had already invested in opening and in branding and were expecting a whole bunch of things, but they had bought a ton of cars at auction to put on the lot, and they were not able to actually operate there because of the way the county enforced the zoning rules. Two things I learned from that case. Number one, it's very important to make sure that the dealer can actually operate in the location that the dealer wants to operate. You may say, duh, but that's a foregone conclusion for a lot of people who enter these leases. They don't think that, hey, it might not be possible to operate the location. The other thing I learned is that the tenant is responsible for knowing zoning. Okay, let me explain what that means. Zoning is public record. The law in Georgia is that the tenant, before signing a lease, should know and is responsible for knowing whether or not the actual business can be placed there. Now, we were able to resolve this complaint. We did file a lawsuit and we got it resolved. Everything's okay at this point. But I learned that through that process, and it's important now, and I tell all my clients now, know that when you're entering into a lease for property, that you know whether or not the business can actually operate in that property before the lease is entered. That should be part of due diligence for every dealer entering into a lease to lease property. Make sure that the dealership can actually operate on that property before signing the piece of paper and executing the lease.